Freetown, capital of Sierra Leone, nestling between the sea and the mountains, provided a compelling backdrop and ambience for the 2024 International Conference of the Ecowas Court of Justice from the 13th to the 16th of May 2024. About 250 dignitaries from across the region converged on the city and the Freetown International Conference Center for what has become one of the most important events on the annual calendar of the Community Court of Justice. The international conferences, which have been hosted across ECOWAS member states, provide a communal platform for informed deliberations on contemporary issues related to the primary jurisdiction of the court, as well as critical thematic issues concerning ECOWAS and the West African community. The theme of the 2024 conference was enhancing the role, relevance, and effectiveness of the ECOWAS Court of Justice through the strengthening of synergies between the court and national stakeholders. The conference participants included notable jurists from national and regional courts, legal scholars, legal practitioners, ECOWAS institutions, civil society organizations, and the international community. The conference opened with President Julius Maada Bio of Sierra Leone in attendance, along with the top hierarchy of the government, as well as the diplomatic community and officials of ECOWAS institutions. President of the Court, Justice Edward Amwako Asante, in welcoming the conference participants, highlighted the pivotal role the ECOWAS Court has been playing in the region in the resolution of legal disputes within its mandate areas. In the address delivered by the Vice President of the Court, Justice Beribe Watara, Justice Asante stressed the choice of the theme of the conference was informed by experience of the court over the last 2 decades and the recurring challenges it has encountered with national jurisdictions in the execution of its mandate. Justice Asante explained that the conference was to look at the strength of the court and its shortcomings with a view to enhancing its effectiveness through strengthening of its relationship with national stakeholders.
Le thème de la conférence internationale de cette année est le renforcement du rôle, de la pertinence et de l'efficacité de la Cour de justice de la CEDEAO par une synergie accrue entre la Cour et les acteurs nationaux. Ce thème est d'une importance capitale pour la communauté, car après 2 décennies de fonctionnement, la Cour ainsi que divers acteurs nationaux peuvent avoir des attentes et des préoccupations non satisfaites concernant le rôle, la pertinence et l'efficacité de la Cour et ses relations avec les juridictions nationales des États membres. Je reste convaincu que cette conférence sera intellectuellement très stimulante et que le résultat qui sera utile pour renforcer les synergies entre la Cour de justice de la CEDEAO et les juridictions nationales.
President Julius Maada Bio of Sierra Leone is happy with the ECOWAS Court for bringing the international conference to his country. He noted that ECOWAS member states are bound by the common objective of integration, peace and development, and acknowledged the pivotal role of the court in providing additional justice delivery options to community citizens.
The added layer of checks that the court provides will not only raise awareness of the members' human rights questions, but also ensure that member states do more to uphold the human rights of our citizens. We recognize the critical role of the Ecowas Court of Justice in safeguarding the principles and providing recourse to those whose rights have been violated. Sierra Leone has always cooperated with the court. We note in particular that the current composition of the court has one of our own Honorable Justice Mohammed Sengu Koroma from our Supreme Court. I would like to commend the efforts of the ECOWAS Court of Justice in promoting judicial cooperation, facilitating access to justice, and strengthening the rule of law in West Africa. I urge all member states to support the courts in its mandate fully and to implement its decisions in good faith.
The ECOWAS Parliament, represented by its fourth Deputy Speaker, Honorable Bilay Tunkara, declared the ECOWAS Court of Justice in the execution of its human rights mandate has become a beacon of hope for people in the region who cannot find justice in their countries.
It is concerning that lately, the independence and mandate of our community court has been attracted attention from different quarters relative to its legitimacy. It is no gainsaying that increased state conscience to the jurisdictions and compliance with the usual community court will strengthen the rule of law, as the rule of law is all that stands between peace and crisis, as well as stability and instability. I wish to commend the ECOWAS Community Court of Justice for upholding the values of our judicial system and representing the pluralism of our society. You will all agree with me that the quality of judicial deliberations and legitimacy of judicial outcome go hand in hand with experience and trust, as well as the independence, competence, and impartiality of the court.
Attorney General and Minister of Justice of Sierra Leone, Mohamed Lamin Tarawali, was on all fours with this submission and acknowledged that the ECOWAS Court has become a guardian of regional integration. Reiterating his country's commitment to the court, the minister emphasized the need for more synergy between the community court and national stakeholders.
ECOWAS Court of Justice and national stakeholders is indeed vital for fostering robust legal framework and ensuring effective implementation of regional decisions. I suggest today that ECOWAS member states should promote the inclusion of ECOWAS community law.
Acting Chief Justice of Sierra Leone, Justice N.C. Brown Mark, was concerned with how member states can ensure due compliance with decisions of the Community Court of Justice. His submission was anchored on the fact that these countries had formally recognized the jurisdiction of supranational bodies such as the ECOWAS Court.
Each of our countries treasure our independence from external interference, but having voluntarily joined an organization which is supernatural in its aspect and in its work, we have implicitly agreed that it is beneficial to all of us West Africans to accede to an authority composed of individuals over whom we cannot exercise direct control. Just as in national jurisdictions, litigants might not like the decision of a particular court, but are prepared to comply with that court's decision, so too, there's growing a belief that the same should apply to international institutions of which we are members.
President of the Sierra Leone Bar Association, Michaela Swallow, said legal practitioners and stakeholders have a responsibility to ensure that the court fulfills its mandate as it occupies a pivotal position in the pursuit of justice, equity and fairness for the West African community. She called for increased cooperation between the court and national stakeholders, as well as capacity building and knowledge sharing to foster an environment that will empower legal practitioners, promote access to justice, and reinforce the effectiveness of the court as the stronghold for protection of human rights in the region.
As we deliberate on this theme, it is incumbent upon us to acknowledge the socio-economic, cultural, and legal diversity that characterizes the ECOWAS region. Each member state brings with it unique legal traditions, systems, and challenges to the table. Thus, the importance of tailoring and implementing context-specific strategies to strengthen the union between the ECOWAS Court and national stakeholders cannot be overstated. Our collective commitment aligns deeply with the experiences of citizens across the ECOWAS region who look to the Community Court of Justice for protection and vindication of their rights and liberties in the face of adversity and inequality.
The keynote address for the conference was delivered by Professor Ernest Kofi Abochi, Dean, University of Professional Studies, Accra, Ghana. He extensively reviewed the role and responsibilities of the parties to the theme of the international conference, which are the Community Court of Justice and the national stakeholders. In his final submission, Professor Abochi made submissions on what the ECOWAS Court of Justice has to do to stay relevant.
In the absence of apex courts like ECOWAS, conflicts will be left unchecked, and political tensions and disagreements can quickly degenerate and potentially lead to disintegration in general. If the ECCJ is to succeed and become effective moving forward into the future, it must be seen and preferred as the preeminent dispute resolution chamber of the region in matters falling under its jurisdiction. The court's current model of courting local actor cooperation is a useful start, and its model of promoting doorstep hearings within the countries and the member states promises to deepen the attachment of member countries. I extend my warmest welcome to all of you and wish you fruitful deliberations during this very important conference. May our collective efforts lead to tangible outcomes that benefit our people, region, and uphold the noble ideas upon which ECOWAS was founded.
Attorneys, good witnesses, presenters, Yumwa and Dayu, please.
Thank you very much.
The opening ceremony heralded what would be 4 days of memorable events for the court and the community. The conference devolved into technical sessions for intense deliberation of the conference theme under 5 themes. For 4 days, resource persons made up of jurists from the community court and national jurisdictions, judicial officials, legal luminaries, academics, and subject matter experts provided context, perspectives, and insights for informed discourse on the 5 sub-themes. Sub-theme 1, assessing the role, relevance, and effectiveness of the ECOWAS Court of Justice, relevant benchmarks, and theoretical perspectives.
If you compare the ECOWAS Court of Justice with other regional economic courts in SADC, EAC, Maghreb Union, CEMAC, and SAD, etc., you will actually find that consistently the ECOWAS Court of Justice has been adjudged the most productive and the most viable, regional court of justice in terms of the quality and quantity of the jurisprudence it has laid out.
You will recall that recently, Niger Republic brought a case against the authority of ECOWAS, ECOWAS Authority of Health, State and Government. That is the first time a member state is filing a case and not just becoming a defender. Since 2001 that the court was set up, in 2023 was the first time an ECOWAS member state is bringing an action directly to the ECOWAS Court of Justice.
Sub-theme 2, strengthening the relationship between the court and the political arms of national governments, a catalyst for enhancing the role, relevance, and effectiveness of the ECOWAS Court.
When you set up a court, or you conjoin efforts with others to set up a court, that court is not a foreign court. That court is your court. And the decision of that court is a decision of your court, I have endeavored to proffer some solutions in respect of the problem about dualism. I have suggested the doctrine of de-domestication. In respect of the problem about delay or non-appointment of competent national authorities, I have suggested deemed appointment of the minister responsible for justice as the competent national authority.
In the long term, the best way to assess the role and relevance of the Ecowas court may be a rule-based governance environment, which is more likely to withstand political upheavals than a relation-based environment. Even though I also encourage, like I said earlier, public education and really more relation-based work in the states themselves. But we might not be far from getting to a point where, in establishing a clear understanding of the mandate of the Ecowas courts, the combined approaches of dialogue and rules are likely to facilitate compliance with and enforcement of the court's decisions.
We should be very careful how we try to talk about the exhaustion of local remedies, or else violations of human rights will increase.
The Honorable Attorney General of Ghana has clearly indicated his disinclination with the non-exhaustion of domestic remedy. It has not stopped the office of the AG from being appointed and working as the national competent authority to enforce judgment of this court.
We are proposing, and we started doing that we should appoint human rights institutions within the countries, which we feel we think they can have the wherewithal and the strength to see to the enforcement of that. We started doing the proposals and writing to the member states to do that.
Sub-theme 3, enhancing the role, relevance and effectiveness of the Ecowas court through strengthened synergy with national courts of member states.
When laws are passed, treaties are passed outside Sierra Leone, they have to be domesticated. Now, and if they're not domesticated, there is a challenge for courts to enforce it.
The issues of first concurrency of jurisdiction between the Ecowas court and national courts of member states, especially with regard to human rights mandate, does not in the first instance arise. This is because Ecowas court deals with international human rights instruments entered into by member states. The national court continues to deal with questions arising from their constitutions and other allied domestic legal instruments that is applicable to the state.
Sub-theme 4, developing a mutually beneficial relationship between the Ecowas Court, national human rights institutions, national bar associations and law schools in the pursuit of enhanced relevance and effectiveness of the court.
The fact that you can go out of that country to another body composed of people who are most probably not your nationals to resolve the matter is a mechanism of creating peace. It doesn't even matter if the judgment is not enforced. The moral victory that comes out of the judgment in your favor in the Ecowas court is enough.
Sub-theme 5, strengthening cooperation with the media and civil society to improve the relevance and effectiveness of the Ecowas court.
The Ecowas court is indeed the last and final hope of us to establish that. The media must champion that court to ensure that it continues to be effective.
After 4 days of composite submissions, deliberations, and recommendations, the conference came to a close with the adoption of the report and communique.
Finally, is there a motion for adoption of this recommendation subject to the various amendments and motion? Yes, any motion?
I move the motion for the adoption of the
Thank you. Seconded by who?
I, Saka Azimane, hereby second the motion that this report be adopted subject to subsequent amendments.
One of the highlights of the closing ceremony was the presentation of plaques to personalities who had earned it for their outstanding contributions. To give more impetus to the court's sensitization and community outreach initiative, the court presented the Law School of Farabi University, Freetown, with Ecowas Court of Justice law reports with a charge to read more and know more about the community court.
The students as well embedded into the curriculum of the universities and universities. So please accept this as a symbolic presentation of our law students. Thank you very much.
Responsibility for acknowledging the contributions of the participants fell on the Vice President of the Court, Justice Gweribe Ouattara.
Au nom de l'honorable président et des honorables juges et de l'ensemble du personnel de la Cour, exprimer notre profonde gratitude à l'ensemble des participants. Non seulement ceux qui sont effectivement présents dans cette salle, mais aussi ceux qui ont participé en ligne via la plateforme Zoom.
President of the Court, Justice Edward Amwaku Asante, in declaring the conference closed, took judicial notice of the positive reviews received by the court for its critical role in the protection of human rights in the sub-region.
That efforts are being made in some quarters to amend the protocol of the court to introduce the rule on the exhaustion of local remedies. Without that, this is an attempt to renegotiate the mandate of the court and it is posing a great existential threat to the court. If this succeeds, it will drastically reduce access to the Court of Justice by community citizens and other persons living in territories of member states who may be victims of human rights violations. This will weaken the court, and it is definitely not in the best interest of the community and the court. The Ecowas Court of Justice is playing a very vital role in the Ecowas integration process, and that the importance of its human rights mechanism cannot be overemphasized. To member states to take necessary steps to domesticate the Ecowas revised treaty, the Ecowas protocols, and to enact enabling laws that will enable national courts to play a more effective role in the integration process.
Justice Asante reiterated that the court is not in competition with national courts, nor does it act as an appeal court.
The Ecowas Court of Justice has repeatedly emphasized that it is not in competition with national courts of member states. We are a court established by treaty and our mandate is clearly prescribed by the protocol of the court. We are not an appellate court over national courts and we do not have the power to review their laws in abstract. May I, on behalf of the College of Judges and staff of the Ecowas Court of Justice, express the profound appreciation of the court to all our collaborators for your various contributions towards the success of this conference.
As the 2024 International Conference rounded off, the impact was already reverberating.
Well, the conference is very educative, and I see the relevance of it, in our courts as well as the member states. It's been very educative in the sense that the themes that were discussed, had very good impact on those that have been here to represent the member states and also the national judiciaries.
J'ai été très contente de participer à la conférence en tant que juge externe. Mon ressenti après 3 jours de travaux, d'échanges intéressants et enrichissants, c'est qu'il faut accentuer la coopération entre la Cour de justice, la CEDEAO et les juridictions internes. Cela est très important pour la prise en compte du droit communautaire, surtout en matière des droits de l'homme et dans le domaine aussi du droit public interne par rapport aux justiciables de la communauté.
This conference enabled the court to enhance awareness on its existence, its mandate, its practice and procedures, as well as the level of enforcement of its judgment. And with the 3 days of discussion, we were able to achieve that, and also to get participants, resource persons to reflect on how to get court more effective in its operation and in the way it takes its judgment. It also enables us to give a broad awareness to the Sierra Leonean people as well as the whole West African community on the modality for access to the court, so that anybody who is victim of violation of human rights knows how to access to the court, knows that the court exists, how to access to it, and what should be the expectation in terms of fairness, transparency of judicial process at the regional level.
A new precedent was laid at the conference with the organization of a 2-day training program for legal practitioners in Sierra Leone. It acquainted them with the court's jurisdiction, how to access the court, enforcement of judgments, as well as practices and procedures of the Ecowas Court of Justice. It was also a learning curve for the next generation of legal practitioners in member states who will be pivotal to the implementation of the theme of the conference, enhancing the role, relevance, and effectiveness of the Ecowas Court of Justice through the strengthening of synergies between the court and national stakeholders.
I've been attending for this period the Ecowas court training for lawyers and for law students. And it has been really helpful throughout these past days because it helps us to know about the jurisdiction of the Ecowas court, the processes and the benefits of the Ecowas court. So I think it's really, really beneficial, not only for students, but also for us to go out to share this news, this what we've learned to other people, because this Ecowas court also deals with individuals, not only lawyers, but also individuals.
For us law students and lawyers, in shaping our thought processes, our perceptions and appreciations about the court, its efforts and its benefits to all and sundry within the region.